All right, everybody, let's talk about the defenses to homicide. If you are a defendant and you are charged with some form of homicide, let's say murder, first-degree murder, or second-degree murder, there are certain defenses that you can possibly use to either mitigate your charge down to some form of manslaughter, voluntary manslaughter, or involuntary manslaughter. It's possible to use these defenses to even acquit your charge fully. It depends on the situation. Every situation is different, which we'll talk about in a moment. So the first defense I want to get into, which has a lot of sub-defenses, is justification. So with justification, we have self-defense, which means that the defendant had reasonable belief. The defendant truly believed that he or she was under imminent serious bodily injury or even death by the other person attacking that person. An example of self-defense is I have the belief that my friend Riley is going to kill me and he shoots me. I happen to dodge it and I shoot back in order to defend myself because he has a gun and one more shot could possibly shoot me in the head and kill me. That is an example of self-defense. I could raise that in court and possibly either acquit my charge or mitigate it down. It highly depends on what happens in the court, the story, and even what the 12 jurors have to say. All right? Remember, reasonable belief. It has to be reasonable. It can't be a subjective thing. It always has to be objective. That's the first thing to think about when you think about the defense for self-defense. Okay? Let's look at defense of others. That is basically the old example of a man wanting to save a woman who's under attack by her boyfriend, right? It's a noble thing to do. However, the thing about a situation of defense of others is that, yeah, a guy could be defending the woman from imminent harm or even death. However, she could be the aggressor. And if she happens to be the aggressor, the man who's trying to save her, quote unquote save her, does not have the right to step into her shoes and attack the other man who happens to be attacking her because he could be self-defending himself from her, right? Moreover, if this happens, if this is a true story, let's say she is the victim and the man is the aggressor, you only have the amount of rights that she does because you are stepping into her shoes. You only have the amount of rights as she does to self-defend. That's defense of others. That's very important to know. So when you try to defend others, remember, be very careful about what you do because you could possibly be attacking someone who's actually the victim. You never know. It's very critical to think about. And if you kill that person, which is, we're talking about homicide here, remember that. If you defend the woman and you happen to kill the other man because you thought that the man was going to kill her or cause a serious bodily injury, you could be liable for some form of homicide. That's very important to think about. Additionally, we have defense of property. If someone steals my wallet, I do not have the right to use serious bodily harm or imminent death against that person. However, if they come to my castle, let's say that someone is robbing my house. Let's say my friend Wiley tries to rob my home. Okay? I very well could use my firearm to shoot him and to kill him dead if I believe that he is coming inside my home to cause my family and I imminent serious bodily injury or death. That's technically a defense that I could possibly raise to either mitigate my charge or be acquitted from my charge because I had the reasonable belief that Riley was going to burglarize my home and cause me serious bodily injury or death. Lastly, for justification, we have crime prevention. Crime prevention can be very tricky. When you're a private citizen, you can only, it depends on the jurisdiction. All right? But let's talk about common law here. Okay? When you think about common law, what's very important here is that you can only use reasonable force against someone else if that person is a threat to society. whether it's an imminent felony or breaching the peace. It's very tricky. It highly depends on the fact pattern of the scenario that you're dealing with. So crime prevention is not a defense that's raised often in a lot of criminal law exams, but it's a thing to think about. All right? So that's justification. Remember, the key thing you need to remember for all four of these defenses is that there must be reasonable belief that you are under imminent serious bodily injury or death. That the person you're trying to defend is the victim, and that person's under serious bodily injury or death. And when you're under your own castle, your own home, whether it's your apartment, your house, even your own tent, let's say you're a homeless person living in your tent, that's technically still your castle. So if you believe that you're under serious bodily injury or death, you can use a reasonable force, such as using your gun to shoot that person, to protect yourself. In crime prevention, as I said, it depends on the situation. It's pretty great. However, remembering that a crime has to legitimately be committed and it has to be a threat to society. For example, a school shooter or someone going into a grocery store and being a threat to society to cause serious bodily injury or death. But it has to be reasonable and it has to actually occur. If it does not occur, it'll be very difficult to use crime prevention as a defense. All right, let me erase this. We're going to go on to excuse. Excuse has three different things we need to look at. All right, we have insanity, we have intoxication, and we have infancy. All right, so let's move on to over here. I call it the three I's. The three I's. Insanity, the first I, infancy, the second I, and intoxication, the third I. There are three I's to think about here. Okay? For insanity, we have the Ebnotin test. That's what it's called. The Ebnotin right or wrong test. I'm going to write right or wrong over here, but that's important to know. So the Ebnotin right or wrong test really means, under a court of law, that the defendant was so mentally ill. Let's say a person who suffers a mental illness within their head, right? And they did not know that what he or she did was morally wrong under a reasonable person's standards. So what's wrong in our eyes is not wrong in their mental state because they have that mental illness. They're insane. They don't actually probably understand that what they did to the person that they caused imminent death to was wrong. So they can raise this as the defense to be acquitted. It's a possible defense to raise, but that person has to be totally mentally ill. We're not talking about someone who has some type of issue such as anxiety or anger management problems. You're talking about someone who's actually fully insane in the brain. All right? Secondly, we go to the second I, which is called infancy. Okay? There are certain age ranges that are in infancy. So it's very tricky to use this as a defense. However, with the news of a lot of school shooters, it's a pretty big thing that's been used lately. So we go over here. Okay? It's really 0 to 6, but 1 to 6 is still the range. I had an equal sign here and I crossed it off because that will not be considered. Because someone that young is not able to commit a crime, able to commit an actual homicide. So that won't suffice. Moreover, we look at 7 to 14 is a rebuttal presumption. So it's possible that someone who's between those age ranges of 7 years old to 14 years old, that person could be held culpable for their act. It's possible. However, like I said, it depends on the situation and the facts of the situation. And moreover, as I said, with young kids committing a lot of crimes lately, it is really on the prosecution to prove that the infant, under the law, if you're 18 or younger, you're still an infant, that person had the mens rea, the mental intent to commit that act. Lastly, 14 or older is held to an adult standard. So there's no problem. You're 14 or older, you commit a crime, if you end up killing somebody, You cannot raise infancy. Infancy will not be a defense for you. Okay? You're 14 or older, no problem. Person can be prosecuted to the max. You're held to an adult standard at that point. All right? Lastly, which is my favorite defense of them all, is intoxication. This is the defense that's most frequent in a lot of law exams. A lot of criminal law exams, this is brought up all the time. Okay? So we look at let's talk about voluntary manslaughter first. Voluntary intoxication, I'm going to say, is that I put SI for specific intent crimes. This is only the defense for specific intent crimes. So let's say that my friend Israel purposely gets high, whether it's him doing meth, cocaine, or smoking a lot of weed. And lastly, the most famous is getting intoxicated off alcohol. He doesn't even know what he's doing mentally because he's so intoxicated, right? Let's say that happens to him, and he happens to commit a homicide. Okay? He can only use voluntary intoxication as a defense to his homicide charge if he made a specific intent crime. Okay? For example, conspiracy, attempt, or solicitation, those are examples of specific intent crimes. I don't want to get into that because it's a whole different subject. However, if it's under a specific intent crime, he could possibly raise voluntary intoxication as a defense for his homicide. Let's move on over here to involuntary intoxication. Involuntary intoxication is defense for all crimes. So let's say that you were taking some Advil pills from your cabinet at home. You have a headache, you're trying to relieve it by taking some Advil, and you had no idea that your brother happened to add a bunch of roofies in there. Let's say roofie. They tried to add a bunch of drugs in there that was not Advil pills. You had no idea. You didn't have the mental intent in your head that you were going to take pills that were going to make you intoxicated, right? So you can use this as a defense to say to the judge and to the jury that, look, I had no idea that I was intoxicated. I did not purposely get intoxicated like I did over here, okay? I didn't make that decision. It was against my own will. However, it can be tricky because if I'm at a Chris Brown concert, okay, I'm at a big rap R&B concert, okay, and someone hands me a bag of brownies, and I voluntarily, I take it inside my body, and I get intoxicated. I didn't realize that there was weed brownies. Those are weed brownies. However, that might not cut it for involuntary intoxication because it was pretty obvious that in a setting like that, from a random guy giving me some brownies, it was pretty obvious that I should have reasonably known that there would have been drugs within the brownies. Okay? So let's get into the last thing. What is mitigating it down? I call this mitigation. Okay? So you already saw this. Let's get into mitigation. Where you can mitigate your charge down, whether you're charged of murder, first-degree murder, or second-degree murder, to voluntary man. So let's talk about the heat of passion. The heat of passion is very important in voluntary manslaughter, which for those of you who don't know, voluntary manslaughter means the intentional homicide of another with your intent, with your malice, intent to kill, with your malice mitigated. So it's not as serious as first-degree or second-degree murder. So let's talk about heat of passion. The heat of passion. It has 4 critical elements. All right, we got element 1, which the defendant was provoked. Let's put that down. I'm going to put D for defendant. So defendant was provoked. An example of this is my brother Sanafik coming home from work early to his home, and he finds his wife in bed with another man. That act, Sanafik walking to his home bedroom and seeing his wife with another man, that is the provocation that provoked him. That's an example of the defendant being provoked under the heat of passion. Moreover, let's get to the second element, that this provocation made the defendant act with passion rather than reason. I'm going to put passion rather than reason. So for element 2, Sinophic acted with passion rather than reason when he started to freak out when he saw Carmen in bed with another woman or another man. That made him act with passion rather than reason. Okay? Sinophic got his shotgun and he ended up shooting Carmen in the head, or shoots the neighbor in the head who's in bed with Carmen, right? That is an example of Sinophic being provoked by what he saw with his spouse being in bed with another person. And Sinophic acted with passion at that moment in time rather than reason. Okay? The third element is pretty important too. I think this third element is the most important element in the heat of passion. I call this the reasonable person test, the RPT test, the reasonable and prudent person. So I'm going to put RPT here. RPT, that's just short for reasonable person test. So a reasonable person under Sinophic's same or similar circumstances had to have been able to be provoked like he was, and the reasonable person had to act with passion rather than reason in that same situation. And I think it's pretty reasonable to say that if anyone sees their spouse in bed with another person, that person is going to freak out. That person is going to be provoked. That person is going to act with passion rather than reason. I'm not saying that the key thing that someone should do is kill somebody. However, if that does happen, the court may understand that it's reasonable for Sinophic to act with passion and be provoked at what he saw and make the decision to kill either Carmen, the neighbor, or both through him being provoked. Okay? The reasonable person test is very important. Okay? Moreover, we have one last element to prove. I'm going to erase these three because I don't have enough room. So I'm going to put the last element right here in a moment. So we have this thing called the cooling off period. I'm going to put quote, cooling off. So what's really critical about cooling off? This is the cool off period. This is the fourth element that must be proved within the fact pattern of your criminal law essay. Okay? So proving every single point and defining every single point and analyzing every single point in your analysis with the heat of passion in order for the defendant to mitigate his charge down to voluntary manslaughter. Okay? So the cooling off period really means that the defendant had time to cool off. That the defendant had time to have substantial time to allow himself to not act rashly. That the defendant had time, whether it's, I'm making this up, let's say it's a day or a week or a month, to relax and calm his mind, his mental intent from committing that intentional act towards the victim that he or she shot, right, and killed. So the cooling off period is very important to think about, because a reasonable person would have time to cool off and to relax from that provocation instead of acting with passion rather than reason. That's the fourth element to prove, right? And if the defendant did not act, the defendant took, let's say the defendant took a week. Let's say Sinophic took 1 week to shoot the neighbor for being in bed with his wife. Sinophic cannot hold the heat of passion because he had time to cool off. Because a reasonable person within that time frame would have had time to cool off from what just happened. So this is sort of a rebuttal argument the prosecution used to say that, look, the defendant had time to cool off. So the defendant cannot raise the heat of passion to mitigate his charge from whatever he's charged of to voluntary manslaughter. But the defense can try. They can try. However, if this can be proven that the defendant had time to cool off, then the heat of passion will be very hard to uphold in court. So let me just erase this quick. And then last but not least of the defenses is imperfect self-defense. Okay, it's very important to know. I'm going to write it down here. All right, what's really critical about imperfect self-defense is that the defendant reasonably believed that he or she was under attack. So let's put a reasonable belief. So the defendant reasonably believed that he or she was under attack, but the defendant was not really under attack. For example, let's say that my friend Riley and I got into a big argument, and he told me that, Sam, I'm gonna get you back, dude, for putting me under all this stress. A week passes by, and during that week time frame, our friend Israel tells me that Riley has a gun. Riley has a weapon, and he's going to use it against you to get payback for what you did to him, right? I see Riley the week later, and Riley comes up to me. I see him from far away, and he's trying to make things right. He's trying to come up to me to apologize, to be friends again, and to work things out. However, when I see Riley reach into his pocket, I think that he's going to get a gun because of what Israel told me, right? The reasonable belief. I had the reasonable belief in my mind that Riley was going to use that weapon to cause harm to me, all right? So I shoot him. I use my weapon and I shoot him. I shoot him dead. That is an example of imperfect self-defense because it's not true self-defense. However, in my mind, I had that reasonable belief that Riley was going to cause serious bodily injury or death to me. It's similar to self-defense, however, it's imperfect self-defense because I was not truly under attack. That is the big difference. And these are the defenses that one need to think about when you are taking your criminal law exam, or even when you're thinking about a lot of cases that you see on the news or you happen to see in articles, whichever one you happen to come across. So I hope that these helped. I hope that I explained it well, and I hope that you have a better understanding of what defenses actually mean in relation to homicide. Thank you so much.